So the topic we are going to be looking at this today is territorial jurisdiction of the code. We are going to be looking at the topic territorial jurisdiction of the codes. And as you all know, the penal code is applicable in northern Nigeria. Offenses that are committed in northern Nigeria, the code that is applicable is the penal code. Now, offenses that are committed in southern Nigeria, the code and the law that is applicable is the criminal code. That is settled. However, what if an instance happen where the initial element, or let me use an illustration, where Mr. A commits an offense. Mr. A first of all kill Mr. B. Mr. A kills Mr. B in Lagos, which is governed by the criminal code. And then this same Mr. A goes to Kaduna, which is governed by the penal code, and he kills Mr. C. Which code will be applicable? Is it the criminal code, or is it the penal code? Or is it that Mr. A will first of all be taken to Lagos, then be tried under the criminal code, and then subsequently he will be taken to Kaduna to be tried under the penal code? Is that so? So this brings us to territorial jurisdiction of the codes. Now, you must first of all understand the meaning of territorial jurisdiction of the code. And this brings us to the case of Dariye versus Federal Republic of Nigeria. Dariye versus Federal Republic of Nigeria, where the court defined territorial jurisdiction of the code, territorial jurisdiction as the geographic area, within which the authority of the court may be exercised, and outside which the court has no power to act. That is the way the court, in the case of Dariye versus Federal Republic of Nigeria, defines territorial jurisdiction as the geographic area within which the court has authority to exercise, and outside which the court has no authority to act. So that is territorial jurisdiction of the code. Now, territorial jurisdiction of the codes could be seen in section 4 of the penal code, and it can also be seen in section 12A of the criminal code. Now, before stating what is under these provisions, you must first of all understand the term initial element and subsequent element. You must understand the meaning of initial element and the meaning of subsequent element. So, initial element simply means the first offense, the initial offense committed, the first offense that was committed, while subsequent element literally means the subsequent offense or offenses that were committed, or the subsequent, or something like the second offense that was committed. Initial element, the first offense; subsequent element, the second offense that was committed. So that's the difference between initial element and subsequent element. So anytime you hear me mentioning initial element, I'm referring to the first offense, and then you hear me mentioning the subsequent element, I'm not talking of plain element, I'm talking of the subsequent offense, I'm talking of the second offense. Initial element, first offense; subsequent element, second offense. Now, let's then speak on what the penal code and the criminal code provide under section 4 of the penal code and under section 12A of the criminal code. Now, under this provision, it provides that if the initial act or omission of an offense occurs within the territory covered by the code, and other element occurs outside the territory, then the committer or offender is liable as if all the subsequent elements had occurred within the territory. Now, that's the first part. That's just the first part. Now, what this part is trying to tell you is that initial element. If Mr. A commits the initial element within the territory of either the penal code or the criminal code, and then he moves on to commit the subsequent offense, the subsequent element outside the code. What this particular part is trying to say is that Mr. A can be tried as if both the initial element and the subsequent element occurred within the territory of the code. That is what it says. It simply means if Mr. A, let me use the criminal code for example. If Mr. A, under the criminal code, Mr. A kills Mr. B in Lagos. Now, that's the initial element. And then this same Mr. A goes to Kaduna under the penal code and kills Mr. C. What this part is trying to tell you is that both it will be assumed as if Mr. A killed Mr. C within the territory of the criminal code. Mr. A will be charged and convicted for both the offense that he committed in Lagos and the one he committed in Kaduna. It will be assumed as if Mr. A committed both offenses within the territory of the criminal code. That is the same way if Mr. A commits the offense under the penal code. So let me now take the penal code for example. It simply means if Mr. A commits the initial element, that's the initial offense, the first offense within the territory of the penal code. If Mr. A kills Mr. B in Kaduna, that's the initial element. And then this same Mr. A goes to Lagos and kills Mr. C. What section 4 of the penal code is trying to say is that Mr. A, both the offense that Mr. A committed in Kaduna and the one he committed in Lagos, he can be tried and convicted in Kaduna. So that's the first part. Now, the second part is if the initial act or omission of the offense occurs outside the territory. Now, the initial element occurs outside the territory, and then the subsequent element of the offense occurs within the territory, and then the offender enters the territory. He will be liable as if the initial act or omission had occurred within the territory. So, what this part is trying to say, now let's use the criminal code. This part is trying to tell you that if Mr. A kills Mr. B in Kaduna, which is under the penal code, and then this same Mr. A comes to Lagos and kills Mr. C, which is the subsequent element, in Lagos under the criminal code. Now, what this part is trying to tell you is that the court in Lagos can try Mr. A for both the initial element that occurred in Kaduna and the subsequent element that occurs in Lagos. So, if the initial element occurs in one part of the code and the subsequent element occurs in another part of the code, what section 12A and section 4 of the criminal code and penal code is trying to say is that the offender can be tried for both the offense that was committed outside the code and the one that was committed within the code. So it's not that Mr. A will be taken to the High Court in Lagos and then be taken to the High Court in Kaduna. So it's not so. The courts in Lagos will assume as if both the one that was committed in Lagos and the one that was committed in Kaduna all occurred within the territory of the criminal code. So that is what section 12A of the criminal code is speaking about, and section 4 of the penal code is referred to. Now, to further illustrate this, let's then look at the locus classicus case, the leading case of Patrick Injoven versus the state. Patrick Injoven versus the state. So, in Patrick Injoven versus the state, this was what happened. In the case of Patrick Injoven versus the state, the appellant, which is Patrick Injoven, the appellant, which is Patrick Injoven, and others, they are baited. They knew of a robbery In fact, they knew of a robbery that was going to take place in the north. Now, Patrick Njoven is in Ibadan, Oyo State. Patrick Njoven is in Ibadan, Oyo State. Now, they knew of a robbery that was going to take place in the north. They knew of it in Ibadan, Oyo State, and they knew that this robbery is going to take place in the north, which is Kwara State. And they were policemen. Do you know what they did? So they abated the robbery. They conspired with the robbers and they said, oh yeah, go and commit the offense. We will protect you. We will make sure that you are not persecuted for this offense. We'll make sure you are not tried for this offense. We'll use our authority and our influence to protect you. Now, that's the first offense. That's the initial element. Their act is referred to as the initial element and is referred to as the offense of abatement. They conspiring. They abated with the robbers. We will protect you. We will use our influence to cover you up. Now that's referred to as the offense of abatement. Now that's the first offense. And where did this offense occur? It occurred in Ibadan, Oyo State, which is governed by the criminal code. Now the robbers went to Kwara State and committed the offense of robbery. The robbers went to Kwara State and committed the offense of robbery. And when they came back from Kwara State, they brought some of the stolen goods and they gave it to them. So they were tried and convicted in the courts in Kwara State. Patrick Njoven was tried and others were tried and convicted in Kwara State. And the objection that was raised by the appellant was that they ought not to be tried by the courts in Kwara State, stating that the offense of abatement took place in Ibadan. So why should we be tried and convicted by the courts in Kwara State? We should be tried by the courts in Ibadan for the one we committed in Ibadan. Then we'll be tried by the court in Kwara State for the one that we committed in Kwara State. That was what the appellant was stating. Now, what did the court say? Now, look at what the court stated. Now, Kokachiesi delivered the judgment that they were properly tried under the penal code. Although the initial element occurred outside the territory of the penal code and then they were tried under the penal code, the court held that they were properly tried under the penal code, even though the initial element occurred outside the territory of the penal code. Now, in explaining this further, let's then look at the case of Emba versus the state. Let's look at the case of Emba versus the state. Now, in the case of Emba versus the state, the first attempt on the life of the victim took place in October 2001 in Abuja. Now, that's the initial element. The initial element took place in Abuja. The initial element to take the life of the victim took place in Abuja, October 2001. That's the initial element. That was the first attempt by the accused to take the life of the victim. Now, the second attempt took place in Anambra State. The second attempt by the accused to take the life of the victim took place in Anambra State. And then this accused was then tried and convicted by the High Court in Abuja for both the one that took place in Abuja and the one that took place in Anambra State. And then they raised an objection stating that no, we cannot be tried for the one that took place in Anambra State under the penal code. That's what they were stating. They stated that yes, we committed one in Abuja and then we committed another offense in Anambra State, which is under the criminal code. So why should we then be tried for the offense that we committed in Anambra State under the criminal code, under the penal code, when Anambra State is governed by the criminal code. Now, the court held that the first attempt, which occurred in Abuja, was a continuation of the second attempt. So they were properly tried by the court in Abuja, although the initial element occurred in Abuja and the subsequent element occurred in Anambra State. The court simply stated that they were properly tried for both the initial elements that occurred in Abuja and the subsequent element and the second offense that occurred in Anambra State. So looking at the cases I have given so far, you will see that where Mr. A commits one offense in a state governed by the penal code, and then he moves on to another state governed by the criminal code, both the penal code and the criminal code can try Mr. A for both offenses. So it's not that Mr. A will be taken to Lagos to be tried under the criminal code and then taken to Kaduna to be tried under the penal code. Both courts can try Mr. A for both offenses. It will be assumed that both the initial and the subsequent element occurred within the territory of any of the particular code where Mr. A is tried under. Now, to further explain this, let's look at the case of Haruna versus the state. The case of Haruna versus the state. So, in Haruna versus the state, it was held that a conspiracy hatched in Lagos. A conspiracy hatched in Lagos to commit offense in the north was triable in the north. This conspiracy, which is the initial element, which is the first offense, which is conspiracy, was committed in Lagos. The conspiracy was hatched in Lagos, and then they went to the north and committed this particular offense. And now, upon committing this particular offense, in the case of Haruna versus the state, they were not tried in the north for both the conspiracy that occurred in Lagos and then the offense that they did in the north. So they will raise an objection stating, no, we cannot be tried for the offense that was committed in Lagos under the penal code. But however, the court held that the court in the north has the power to try them for both offenses. That is what territorial jurisdiction of the code is all about. Yes, the penal code. Yes, if an individual commits an offense entirely under the penal code, the code to be applicable, the law to be applicable is the penal code. If he comes to the south and then commits an offense, the code or the law to be applicable is the criminal code. However, where the initial element occurs in the criminal code, in the territory covered by the criminal code, and then the subsequent element, and then the secondary element or the second offense was committed in the territory governed by the penal code, both the criminal code and the penal code is applicable. And if they are to try that individual, they will try the individual for both offenses, for both the one that was committed outside and the one that was committed within. Now, let's also look at the case of Mora versus Federal Republic of Nigeria. Mora versus Federal Republic of Nigeria, where it was stated that if part of an offense, just a part of an offense is carried out in one state, and the other part was committed in another state, the offender can be held liable as if he committed the whole offense in the state where the initial part was carried out. So you see what this case is trying to say? This case is trying to say where one part of the offense is committed within the territory of the criminal code, and then the The second part of the offense was committed within the territory of the penal code. Both codes, both courts can try that offender. And it will be assumed if they are to try the offender, they are not going to just try the offender for only the part that was committed within their territory. They will try the offender for both the one that was committed within the territory and the one that was committed outside the territory. So this is what territorial jurisdiction of the code is speaking about. So when one part of an offense occurs within the territory of the criminal code and then another part occurs within the territory of the penal code, both codes are applicable, and if the offender is to be tried, it will be assumed as if both offenses occurred within the territory of the code. So the offender is not going to be transported from one state to another. Now, the next question you are going to ask yourself is, what if Mr. A, what if Mr. A fires a bullet at Mr. B in Lagos? Mr. A shoots Mr. B in Lagos, and for one reason or the other, Mr. B was taken to Kaduna for treatment, and then in Kaduna, Mr. B dies. With that, is that enough to vest the court, the High Court in Kaduna, with sufficient jurisdiction to try the matter? Is the death of Mr. B in Kaduna enough to cover the courts in Kaduna with sufficient jurisdiction to try Mr. A? The answer to that is no. It is not enough to close the courts. Death is not enough to close the courts with jurisdiction to try such offender. So this is it for territorial jurisdiction of the code. When either part of the offenses, be it the initial element or the subsequent element, occurs within the territory of the code, and another one occurs outside the territory of the code, the offender can be tried as if all the offenses occurred within the territory of the code. So Mr. A will not be transported from one state to another. He will not be transported after being tried, after the High Court in Lagos have stated you are sentenced to 20 years imprisonment. Then Mr. A will now be taken to Kaduna. Then the High Court in Kaduna will now be like, you are sentenced to 20 years imprisonment. They will now look like 40 years. No. The High Court in Lagos will assume as if all the offenses occurred within Lagos. So the High Court in Lagos will try Mr. A for both the one that occurred within Lagos and the one that occurred in Kaduna. If Mr. A is to be tried in Kaduna, Mr. A will be tried in Kaduna for both the one that occurred in Lagos and the one that occurred in Kaduna. So this is it for territorial jurisdiction of the code. As usual, by name, I am Japhet Okaka Ebusetai. Thank you so much for watching.